Good morning, everyone. So I'm Professor Vivek Joshi, President IIC MHRD Initiative and Coordinator of Student Startup and Innovation Policy Cell R.N.G. Heartily welcomes you all. So we are great to have today with us Mr. Vijay Kumar Makyam. So sir, I heartily welcome you and thank you very much for accepting our invitation. So, Mr. Vijay Kumar Makyam is a postgraduate in law with specialization in intellectual property rights and Master of Science in Information Technology. Had practiced intellectual property law for 15 years. He had initially enrolled with the Karnataka Bar in year 2005 and got transferred to Telangana Bar. He had been counseled on record in various IPR cases before different high court in the country. He had been guest faculty at National Institute of Micro, Small and Medium Enterprise, Hyderabad, and National Institute of Pharmaceutical Education and Research, Hyderabad. Sir is also a resource person for University College of Law, Osmania University, JNTU Hyderabad, JNTU Kakinada, Ministry of HRD, Ministry of MSME, and various other universities for promotional of IPR. Sir has attended JPO training program during 2017. Also, sir is a recognized patent and trademark agent for Indian Patent and Trademark Office and has filed and prosecuted patent and trademark applications and oppositions before the Controller of Patent and Trademark Registrar in India. He has also coordinated filing of patent and trademark application in other countries including USA, EU, Australia, Malaysia, Singapore, Sri Lanka, South Korea, South Africa, UAE, and Japan. Sir has published an article titled Unintentional Abandonment of Patent Application Law in India during August 2018. Also, sir is instrumental in organizing various seminar, training sessions, and moot court composition. So, we are great to have very such eminent personality with us. Sir, once again, I heartily welcome you, and I hand over to you to guide us regarding patent filing process in India. Thank you very much, sir. Over to you, sir.
Thank you. A warm welcome to you all. Thank you for inviting me here. And it's a great initiative that the Institute has been taken up for knowing this specific knowledge on IPR. Let me share my presentation and then go ahead.
Yeah, sure, sir.
Yeah, hope all of you are able to see the presentation, right?
Yes, sir. Presentation
Yes,
is visible, sir.
Great. So before I begin anything on this discussion, I just want to give a formal disclaimer. This presentation is meant for only educational purposes. The materials, slides are reflecting my personal view and does not reflect the views of my organizations I'm associated with, either IPAB or IVN IP Services, any other organization I'm associated with. It is not their presentation. It is my personal views. And further, it is understood that every situation is fact specific. So you need to be having a specific advice for specific case from appropriate patent attorney. This is only a generalized view of what is law and how it need to be followed and all. In this session, I'm going to talk about the basics of patent law, the international conventions and treaties, and Indian patent law, and how the patent filing required to be done in India. And as well as any other topic you might be interested in question and answer session, we can discuss that as well. So basics of patent law, it is on a principle, the patent law runs on a principle called quid pro quo. Quid pro quo means, it's a Latin word, quid pro quo, which means give and take. You give your knowledge to society. Society represented by a period of time. So that is give and take policy. You're giving knowledge, government is giving some rights to you. So doing that, what is happening is progress of science and technology. Government wants the science and technology to be prospered, science and technology to be progressed. That's the reason these patent rights are to be given to the inventors for their voluntary disclosure of the knowledge what they gained. So the inventions what you develop, that the inventions required to be disclosed. To be disclosed, they are giving some patent right which gives you monetary benefit. That's the reason it is both the recognition of you as an inventor, as well as because you have invented for 20 years, you will be given monopoly rights so that you can alone sell and make money out of it. So this twofold objective has been arrived by patent law. Now, there are basic requirements for granting a patent or refusing a patent. The basic requirements are primarily it is novelty, utility, and non-obviousness, but I have also added patentable subject matter and specification to it. Patentable subject matter is not all subjects you get patent. If there is a myth that if I write a book, I get a patent. If I write an article, I get a patent. No. If you write an article or if you write a book, at the best you will get a copyright, not a patent. So patents are given to inventions, a new product or a process of making a new product. To that, patents will be given. Patents will be given to technological products, not a script that you have written, or there are certain subjects that are also excluded from patenting, like Section 3 of Indian Patent Act talks about what subjects are not patentable, like plants and animals and parts thereof, computer programs per se, business methods, or anything which you have synergized and made a new product. Those kind of things will not be patentable. So it is away from the patentable subject matter. So your product, your invention should be a product or a process, any new product or a process, but it should not fall under Section 3, and Section 4 talks about atomic energy related patents. So if it is not atomic energy related patents or not falling under Section 3 and it is a product or process, then it is patentable subject matter and it will be granted patent. These requirements will be like a filter. If you pour inventions from the top, if these filters need to be cleared to get a patent grant. So first level of filtration is patentable subject matter. Then comes novelty. Your product should be really new to get a patent. If it is already existing somewhere in the world, then you won't get a patent. So patent will be granted territory specific, that if Indian patent is granted, it is applied only India. Each country is sovereign itself. So you can't, Indian government can't grant a patent in USA or UAE or some other country. So Indian patent is valid only to the territory of India. However, while checking novelty, Indian government checks throughout the world. If there is something similar existing any part of the world, patent will not be granted. If you have a myth saying that if it is existing in Australia but it is not there in India, I want a patent in India, you won't get it because it is already there in Australia. You won't get the patent in India. So that is the concept of novelty. So novelty need to be it should be new throughout the world. Anywhere it should not be existing. If it is existing somewhere, that knowledge knowledge about that product or that invention already existing, then you won't get a patent. Again, your own disclosures. Sometime you disclose it. You might have made a thesis, a PhD thesis, and submitted in the college, and simultaneously you filed a patent application. Before you file a patent application, your thesis is kept in the library, and library is a public place. Everybody and anybody can see it, right? Your own thesis, somebody has seen it before you file a patent application. And then once you file a patent application, he says that no, this is not new because it is already in public domain. It is already in library. Library is a public place. Everybody knows about it. So once everybody knows about it, you can't file a patent application. Most often what happens, entrepreneurs and students, people come to me and say that, sir, there is wonderful product I made. I'm selling it in the market, and it is I'm getting tremendous response from the purchasers, and some of the purchasers suggested me to file a patent application. That's the reason I'm coming. You have already sold the product in the market. This knowledge become public. Everybody knows about this product. Then how can you file a patent application? for filing a patent application, the minimum requirement is it should be new. So when it will be called new, when it is not known to public. So if your invention is, if you're feeling that your invention is capable of protection under patent law, you should keep it secret until you file patent application. Once you file a patent application, that is okay, but until you file patent application, it need to be kept secret. Once you file a patent application, next day you can call for a press conference and you can declare about your invention to the press. And you, after filing patent application, if you keep mum, it is losing your revenues. You need to widely canvas, you need to say throughout the world, saying that I have invented this, I have invented this. And if somebody wants a license of that, they'll approach you and take a license from you. So that is the reason, until filing application, you need to keep it secret, and you should not open your mouth, even for your friends and professors, anybody you are discussing your ideas. You need to be very careful while discussing the patentable subject matter, which you are intending to file patent application. You should keep it as minimum as possible, the communication. If you communicate it and it goes in the public domain, then you are killing your own novelty. So you need to be very sure of keeping the invention secret until you file the application. After filing the application, you are free to disclose it to anyone and everyone throughout the world. Then the other requirement is utility. Utility means, in India, we call it as industrial applicability. Whatever invention you have made, you are not going to file a prototype or a machine to the patent office. You will be filing a specification. You will write a document about that invention, and that document you will file in the patent office and ask for grant of a patent. When you are doing that, when you file a specification, people who want to manufacture that product, they'll read that specification, and if they understand, then they'll manufacture the product. The idea, the objective, the basic principle of the patent law is quid pro quo. That means give and take policy. Like when you're giving, what is that you're giving? You're giving a vague information, or information through which people can use it and make products in the industry. Industrial applicability. That means by reading your specification, the person skilled in the art, the person who is a basic graduate in that particular technology, by reading your the specification what you have given, should be able to manufacture in the industry. That is what utility means. If he is unable to manufacture in the industry by your description, then it is said to be that your invention is not capable of making industrial application. If it is not capable of making industrial application, patent will not be granted. That is another requirement in the patent law. It has to be some utility. Suppose something like this: if you have invented an invention for which there is no raw material in the world, even though it might be a great invention, but since there is no raw material in the world for making the product, there is no utility to it. So patent will not be granted to it. Likewise, if you made an invention, maybe a time machine you have constructed, it is working very well, it is going in time and coming back, but you don't know how you have constructed, what computer coding you have given, what nuts and bolts you have fixed, you forgot about it. You can't build a second product. So in such situations also, it is said to be lacking utility, and patent will not be granted. And the third requirement, the fourth requirement is non-obviousness, or in India we call inventive step. To be granted a patent, not only it should be new, but it should also involve some inventive step. There should be some innovative mind applied to come up with that invention. If there is no inventive step involved, even though if it appears to be new, the patent will not be granted. For example, if there is a chair with 4 legs is already existing, and you made a invention with a chair with 3 legs, you managed to balance the flat panel with 3 legs, and you submit it for a patent. There is nothing great about managing the flat panel when it has been on the 4 legs. Managing it on 3 legs there is no innovative inventive activity going into it. That's the reason it will be said to be obvious. Obvious means very simple, anybody can think of. So such kind of inventions will not be patented. However, this non-obvious requirement is subject to what is technical to me might not not be technical to you. That's the reason this obviousness requirement will be viewed viewed in the eyes of a person skilled, ordinary person skilled in the art. That means a fictitious person will be created who is an ordinary basic graduate of the technology. He will look into it. If I ask a PhD guy, everything will be obvious for him, but it will be by an ordinary graduate of the technology who will view that. And if he feels that the invention is simple, then the patent will not be granted. If he feels that invention is not that simple, then patent will be granted. I'll give another example for this. Imagine that today we are all using smartphones, right? So smartphone encompasses a digital camera also in the phone itself. So that's the reason we call it smartphone. 10 years back or 15 years back, we used to have mobile phones as well as digital cameras. So when this person filed application for smartphone, the examiner first compares his invention smartphone with mobile phone. When he compares the mobile phone with smartphone, this smartphone has digital camera extra feature. So it is novel. It is not matching with the mobile phone. Then he'll take up digital camera document and he compares this smartphone with digital camera. This smartphone has mobile communication tool extra, so it is not matching with digital camera. In light of existing mobile phone and digital camera, this smartphone is really new product, so it crossed the novelty filter. And then utility filter, it definitely has utility. And then finally, when it comes for non-obviousness, what examiner does is he combines this document 1 of mobile phone with document 2 of digital camera, and in combination your smartphone, he sees whether this combination teaches you or motivates you to come up with this smartphone. Is it that simple to think for the smartphone? And if the answer is yes, if it is simple, then patent will not be granted. If the answer is no, it is complex, even in light of existing mobile phone and digital camera, coming up with smartphone is very difficult, then patent will be granted to you. So that's how the non-obviousness will be examined by the examiner. And you need to also, sometimes non-obviousness objections, if the patent examiner takes non-obviousness objection, you can give a secondary indicia response to that, saying that though this smartphone is in existence of mobile phone and digital camera smartphone, thinking of smartphone is quite easy. For a long period of time, nobody has done it. I have done it first time. And the moment I made the smartphone invention, all digital camera selling has been stopped. People are buying only smartphones. Digital camera sales have been gone down. So that kind of secondary indications will negate the objections of non-obviousness, and patents will be granted to things which got the secondary indication of patentability. Then finally, you need to write a specification. Unless you write a detailed specification, patent will not be granted. You don't require to take the prototype machine to the patent office, but you need to draft a technical specification which will say what is you have invented, how it is been constructed, how many parts are there, how each part is connected to other part, how the overall operation, if there are 4 or 5 methods of working making that machine, all the 4 or 5 methods, and which is the best method according to you, all that require to be going in specification. Unless the specification is written, patent will not be granted to you. Patent application, along with the patent application, you mandatorily require to file a specification of the invention. When you file specification of the invention, the examiner reads your specification, understands it, and then examines your claims in the specification, what is that you have invented, and then he'll grant or refuse patents. If a patent is granted, it is the obligation of patentee that they need to file working of patents every financial year before September. Financial year ends on 31st March. So from 31st March till 6 months, 31st September, the working of the patent statement required to be filed. How many products you manufactured, how many licenses you have given, what is the revenue you have made, that information required to be filed to the patent office on your invention. If you fail to file working of patent information, and if you fail to renew the patent will be revoked. Then the patent law is, there is a myth in the public that patent is confining the knowledge. No. Patent is not confining the knowledge. Patents are for dissemination of knowledge through proper channel. If you don't file patent, if you publish a paper, if you publish in some magazine or some newsletter or some a technical journal, you publish your paper, that reach of that technical journal is only limited people. Not everybody access to that newsletter or journal or magazine. However, when you file a patent application, it is properly classified and kept in the patent. The database of patents is divided into different technological segments like mechanical, electrical, electronics, like that. They divide into different segments, and each segment again subdivided into various subclasses where your type of technology will be stored and saved. The record will be saved there, and whoever doing research in that particular technology will do a patent search and dig out your document, understands what you have made and where the technology is facing. From that stage, he'll do a further research and get further inventions. That's the reason it is properly dissemination of knowledge, not confining the knowledge. Patent is only for 20 years. After 20 years, the entire information will become public. Everybody and anybody without paying any royalty can be used. If you don't file a patent application, that knowledge will not disseminated, and only few people will get to know, and those few people will be working on that invention, not everyone. So patents protects inventions that are new, useful, and non-obvious. Patents are not granted to abstract ideas, the ideas which are not complete. It is incomplete ideas. They will not be granted patents. Physical phenomena like gravitational force or ocean currents or thunderbolts or laws of nature will not be granted patents. When a patent is granted, it gives you it's a negative right. It says that it grants exclusive right to prevent others from making, using, selling, offering for sale, and importing the invention. Patent rights are granted for a period of 20 years. After 20 years, it will go in the public domain. Now, Abraham Lincoln once said, the patent system adds the fuel of interest to the fire of genius. So this statement says that because of the patent system, the interest of genius has been fired, and it is like people come up with more inventions. The genius of the people will increase because of the patent system. Innovation means doing something new that improves a product or process or a service. So innovation or invention means nothing but improving the existing product, existing process, or existing service to a better product or better process or better service. Now, patent law is designed to encourage these kind of inventions, innovations. The myth patent law confines the knowledge is not correct. Patent law is designed to properly disseminate knowledge throughout the world through patent classifications. The objective of patent law is to promote the innovation and encourage the development of domestic. It is not just promoting the innovation, but it is also development of domestic industry. The industries working in our country requires latest technology. If you file patents, the technology will come into the domestic industry, and working of patents is another concept by which the government makes that all patents which have been granted should ensure they ensure that they are being manufactured in the country. So that is the objective of patent law. Patent may be a powerful business tool, allowing inventors to gain exclusivity over new products or process and develop strong market positions and earn additional revenue through licensing and all. Patent protection is usually sought at the R&D stage of the technology lifecycle. The moment it is, because first come first serve. Whoever files first application, he'll get the patent, not the person who files later to him. So later to him, the first application will be cited as a prior art, already existing technology, and his patent will be not granted. It will be refused. Now, governments need to strike balance between protecting intellectual property rights and satisfying public needs. If a public requirement is less, especially for pharmaceuticals and all, currently for COVID-19, government is seeking for waiver of IP rights. So that is because they want to strike balance. They want to promote intellectual property rights for progress of science and technology. At the same time, public needs need to be satisfied. If there is a requirement of public, huge requirement of public, which is unable to be catered by the patentee alone, then government will say, no, everybody can manufacture this. and they need to protect the interest of the inventor. If they don't protect the interest of the inventor, then automatically people will lose interest in disclosing their knowledge and all. So for this better disclosure of knowledge, governments need to strike balance between protecting intellectual property rights and satisfying public needs. Then innovation, competitiveness, and intellectual property rights, maybe it may be patents, copyrights, trademarks, are codependent entities which are also cornerstone for foundation of global economy. Economy to be progressed, economy will be progressed only when intellectual property rights are properly protected and enforced in the country. If you say there is no intellectual property in your country's economy will never progress. It will not go big way. If you want your country's economy to be progressed, you need to protect intellectual property and enforce intellectual property properly. If you see Nokia, right from Talkman, Cityman till the latest mobile gadget, until Samsung and Apple has taken over, they were leading the market with their inventions. Less than 20 years, they made several innovations and inventions and captured the market, and once a world leader in the mobile segment. So this is how you will making inventions and be gaining market advantage, and then you become a market leader for the industry. I'll give one example, importance of patent. There is this guy who has made this ring pull can, which allows a tin can to be opened with a simple technology, and you can have the drink in the can. So that invention he has made, and when Coca-Cola company went to him and asked for a license of the technology, he refused to assignment of the technology. The Coca-Cola want to buy the technology. He refused to assign the patent, and he said, I just want 1/10 of penny per can you manufacture. I license it to you. So the Coca-Cola jumped out of his offer, and initially they said that we'll pay huge money for transfer of technology. He doesn't agreed for that, and he agreed only for 1/10 of penny per can. 1/10 of penny means if they make 10 cans, they pay 1 penny, and if they make 1,000 cans, they pay $1. That is the kind of arrangement, the license agreement he has signed. After signing the license agreement, during the period of validity, the validity of the patent, the inventor obtained 148,000 UK pounds every day as a royalty. He had made his fortune every day for 20 years of his life. He get every day 148,000 UK pounds. Assume that this is not a rocket science. This is a small, simple invention, an invention which has been which does not require a huge R&D laboratory effort and all. That kind of invention, he has made a fortune of money. So this is how the patents help the inventors in making money and building career. However, on the other side of it, not respecting intellectual property rights, there is a case study which is Kodak versus Polarity. Kodak, you all know, is world famous company for manufacturing camera related products. They've launched a new product called instant camera. The moment you click a picture, you get a picture printed on the piece of paper. So that is the instant camera that they have developed, and they released the product in the market. When they released the product in the market, Polarity, who had already filed a patent application for that product and granted a patent, filed a suit against Kodak, saying that their product is infringing their patent rights. Thereby, the suit is decreed in favor of Polarity, and Kodak has asked to pay $935 billion. Kodak, by paying that $935 billion to Polarity, has become bankrupt. Once a world-famous company has now, it is not existent in the world. It has been bankrupt. It has been closed down. So that is the effect of intellectual property, not respecting intellectual property. You may, though you are a big company, you are once a world-famous company, you will vanish in no time if you don't respect intellectual property. If you pay attention to intellectual property, you can make tons of money. If you don't pay attention, you will vanish. So these two case studies explain that. That's the reason I kept these two slides. Now, before I go into Indian patent filing system and all, I would like to tell what is the international law that governing patent filings around the world. the first convention related to patents have been enacted way back 1883. Paris Convention has been signed in 1883. I'll give some small background to this Paris Convention. Paris Convention has been signed in European region. One of the European king, he invited for international exhibition of latest inventions. When he invited first time for the exhibition, there are about 150 to 200 participants and from different parts of the world, and they exhibited their latest innovative products, and it was a grand success. Second year, he wanted to do it every year, and second year he called all of them again for presentation. 90% of them has not turned up. Only 10% of the exhibitors have come up. So he felt very bad, and he wrote to everyone asking what was the reason why they have not come. Is it any hospitality problem? Is there any issues with their atmospheric conditions in the country, or what it is, what went wrong, why people have not turned up? He has wrote to every other participant who have participated in the first year why they have not participated in second year. Then everybody wrote back saying to the king that no, your hospitality, your people, your country, everything is fabulous, but then the moment we exhibit, we are losing revenues. Nobody is coming to us and buying our products. They are making the products on their own. Thereby, we are losing our revenues. Rightful revenues that would have been come to us are not coming. That's the reason we have not participated in the exhibition, is what the reason they have given. Then the king felt very bad. He felt there should be a communication of technology throughout the world without any barriers. So the inventors required to be protected. Inventors' money should be protected. At the same time, they should be able to disclose their ideas freely throughout the world. Then he called for an urgent meeting among European countries. About 14 countries came forward, and they first signed this Paris Convention. About 14 countries in 1883 signed the Paris Convention. Paris Convention says that once a person makes an invention and files in his home country a patent application, and he'll be given 12 months time to file all across Paris member countries. And when he files within 12 months this patent application in all Paris member countries, his date of application will be treated as date of application of the home country. That is called date of priority. Date of priority will be date of priority is recognized in the Paris Convention. And suppose you file application in India on 1st January 2021, you will be given time frame to file in all other Paris member countries within 12 months. That is before 1st January 2022. Before 1st January 2022, if you file an application in any of the member countries of the Paris Convention, your date of filing will be still treated as 1st January 2021, not as the date you file in the respective country. So if somebody else, if you disclose that idea after filing in India, you disclose that idea in an exhibition or something like that, and somebody else goes and files a patent application, he'll be denied a patent application, and you will be given priority over him. That's the reason it is called priority date. And you will be given national treatment. National treatment means whatever rules and whatever fee applicable for filing patent application for the citizens of that country, the same treatment will be given to you also as a foreign citizen. You will not be asked to file additional documentation or additional fee for getting a patent in the Paris member countries. These are the basic principles on which Paris Convention has been signed in 1883, and that has been carried out even today. Paris Convention, there are about 184 countries are members to Paris Convention. All these 184 countries, once you file application in your home country, all these 184 countries provide 12 months time frame to file international application. Then this after Paris Convention, people felt it is the patent process is cumbersome, and they want to ease the patent filing process, and whereby they come up with this new system called Patent Cooperation Treaty. Patent Cooperation Treaty system. That system has been developed in 1970. 1970 when WIPO, this system is administered by WIPO. By then, WIPO has not come up. WIPO has still not taken shape. The member countries were discussing about a feasible system for patent filings and all. And finally, they felt a couple of things, like one thing is, under Paris Convention, 12 months time is not sufficient. They want more time to file in all international in various countries internationally. Under Paris Convention, they want more time, because filing a patent application in different countries, like suppose you want to file in Russia, Japan, China, UAE and all, you need translation of specifications. And translation of specifications, thankfully now we have Google translators and all. Earlier there were no Google translators and all, and every word, especially technological specification, every word is important to translate into a local language, that is something like Russian, Chinese, Japanese or Arabic. All these languages translation was huge, tedious process. It would take years, or 1 year, 2 years, like that it would have been taken. So they want more time for translations and all. And also the inventors spending a lot of money filing applications across the world, when there is prior art existing, or when it can't be patentable, then all that money will be wasted. So they want some kind of assurance, some kind of quality check, or some kind of international report which says that your invention is patentable. Then they are free to invest money and file applications across the world. So under PCT system, what they did is, they want to provide an international search report between 16 to 18 months time. The time frame for filing applications across the world has been increased from 12 months to 31 months. Some countries have 30 months, some countries has 31 months. Like in India, we have 31 months, US has 30 months. Like that, the time frame has been decided under extended under PCT system, as well as within that 31 months, at 16 to 18 months, you get an international search report which says that your invention is qualified to get a grant or disqualified. If it is disqualified, you will not venture into filing several applications around the world. If it is if the report is positive, it is qualified for filing, getting a grant, then you will file multiple applications across the world. That has been designed in the PCT system. In 1970, the PTC treaty has been signed. However, in 1978, the patent PCT applications have been started filing. So since 1978 onwards, PCT system is operational. Then the TRIPS agreement, trade-related aspects of intellectual property rights, to harmonize IP laws around the world. There were different set of rules for patents were existent prior to TRIPS agreement. Something like the term of patent. In some countries it was 7 years, in some countries it was 14 years, in some countries it was 30 years. Like that, there was different terms of protection for patents around the world. So TRIPS agreement is a model law of IPRs have been designed, and the member countries which have signed TRIPS agreements are mandated to apply all that model law into their municipal law, that is their own patent laws. They need to apply that rules. So TRIPS has made it mandatory that 20 years term, and then it made the requirements of novelty, non-obviousness, and utility requirements should be seen while granting patent. These are the common system that has been developed under TRIPS agreement, has been adopted throughout the world, and India is no exception. India also adopted TRIPS agreement. India signed the WTO TRIPS agreement, and then India also adopted TRIPS agreement. However, TRIPS agreement, the transition period for developing countries, they have given 1 year. For developed countries, developed countries, they have given 1 year. For developing countries like India, they have given 10 years transition period. That is 1995, the TRIPS agreement has been signed, and till 2005, the TRIPS agreement need to be implemented in India. And India has changed all its laws. Patent Act 1970 has been amended in 1999, 2002, and 2005 to comply with TRIPS agreement. And there are several other laws also been amended to comply with TRIPS agreement by India. Then there is another agreement called Stansberg Agreement. It is based on for the classification of patentable technologies, the mechanical, electrical, electronics, chemical. All this classification system has been agreed upon, and Stansberg Agreement has been made to classify this technology so that it is easily be retrievable in the database. If any person want to search database, they'll be able to, based on this international patent classification that has been signed and agreed by Stansberg Agreement, all your inventions, when you file a patent application in India, the patent office will assign the class number to it and put it in a database, so that anybody and everybody who are interested in the technology can do a search based on the classification number. Then there is what is called Budapest Treaty. Budapest Treaty has been signed for recognizing institutions which accept microorganism depositing. So microorganisms are also can be patentable. Unicellular microorganisms are patentable, and you can't file a paper for microorganism. If you are claiming microorganisms, you need to deposit that microorganism with the patent office, and patent office will not be able to maintain that microorganism such a deposited, because it takes 3 years, 5 years for patent to be granted. Within the 3 years, if you file it with the patent office, that microorganism would have died in 1 or 2 days, and they would have not known what it is and how it is. So Budapest Treaty says that there is a institution, every country should have an institution which accepts the deposits of microorganisms, and they'll give a certificate of its qualities, quality 1, 2, 3, 4, 5, and that qualities need to be filed. The certificate given by the institution will be filed along with the patent application. And if somebody want to examine the microorganism, that depository institution will have that microorganism, they can examine it there. So that's about international law. Now coming to patent law in India. Patent, what is a patent? It is a legal title granting its holder the right to prevent third parties from commercially making, using, selling, offering for sale, and importing of the patented invention without the authorization of the patentee. This is provided in the Section 48 of the Patent Act 1970. This is a negative right. It is not a positive right. It is not allowing you to do something, but it is allowing you to prevent third parties. So that is how the law or the right has been determined to you. That is what the patent means. It is in return of this protection, the holder has to disclose the invention. As I said, it is quid pro quo policy, give and take policy. You need to disclose your invention. If you don't want to disclose, you want to keep it secret, you have a right to keep it secret. But when you decide to get a patent, you have to disclose it completely, and then once you disclose it completely, then a patent will be granted to you. It is granted for a limited period of 20 years and a specific geographical territory. There is nothing called international patent. There is a process of PTC system which allows you to file PCT international application. Under Paris Convention, you have 12 months. In that 12 months time, you can file a PCT international application. Once you file PCT international application, you will get a 16 month to 18 months international search report, and the time frame for filing application under Paris Convention will be extended to 31 months instead of 12 months under Paris Convention. The PCT system provides extended timelines and the international search report. But there is nothing called international patent. Now, the process in India, how this entire process will go on. The moment you get an idea conceived, you need to do a search. Then the moment you get an idea of a patent, a product to be patented, you need to do a search. And in the search, if the similar things are existing, then you can drop that idea that since already that is existing. If there is nothing similar existing, you can go ahead and draft provisional specification or complete specification based on the information with you. This patent search, there are two schools of people. One school of people say that you should not do any search, because by doing search, your thought process will be influenced with the search results. And some people say that no, you need to do a search to know what is that you are contributing, what is already existing, and what is new that you are contributing. To know that, you need to do a search. And once you get the search results, you need to compare that with your invention, and whatever is the difference between the already existing inventions and your already existing patents and your invention, that is your contribution to the technology, and that alone you can claim in the patent specification, is what the other school of people say. If you are not bothered about patent costs and all, I would recommend that you directly file a patent application without a search. But if you are cost conscious, filing a patent application is not it costs you more. So if you are cost conscious, you need to do a search and ensure that you get a patent grant. Then only you draft a specification and file it. So after search, if the information is full, if the experiments are completed, then you can draft a complete specification. If you feel that there are further experimentations need to come done, then you need to file a provisional application. Once you file a provisional application, you get 12 months time to file a complete specification. This 12 months is same as for foreign filings and the Paris Convention, or filing PCT international application. The same 12 months will be given. There will not be, once you file a provisional application and after the 12 months complete specification, again you won't get 12 months for filing foreign applications. It's the same 12 months for filing complete specification as well as foreign applications or PCT international application. However, if you are unable to unable to file a complete specification within this 12 months, you have a provision for post dating your provisional application to maximum of 6 months. So if you have filed an application on 1st January 2021, you can post date that to 1st July 2021 to the maximum of 6 months. So your application date moves from 1st January to 1st July if you post it. So what happens is, in between, if somebody files on 1st March 2021 some invention similar to yours, he'll be given priority over you. So even though you have filed on 1st January, but since you have moved your date of filing to 1st July, your date of filing will be treated as 1st July only, not as 1st January. And the person who disclosed on 1st March will be given importance over you, and he will be granted patent. Your patent will be denied. That's the reason when you're post dating your application, you need to be very careful when you're moving your date of application to some other date. Then you don't require prototype designing or testing of the invention. It is not mandatory. However, if the patent examiner if he is unable to convince with your idea workable, if he says that it is not workable model and he asks you to make a designing and prove it, then you might require to make a prototype designing and testing. Otherwise, in the normal circumstances, whatever you write a specification, based on that your application will be decided. You don't require prototyping or design. Once you file a patent complete specification, it will be published only after 18 months of your first filing, that your provisional filing date. From the date of first filing, after 18 months, it will be published. If you want early publication, you may request for early publication by paying appropriate fee. Then it will be published early. Once it is published, you can canvass to everyone and ask everyone to stop using this technology without your permission. If somebody is using your technology without your permission, you can issue legal notice and all. But once a patent granted, then only you can file a suit. You can't stop him. You can only issue. You can threaten him for the legal consequences, but you can't stop him after the publication. So once it is published, everybody and anybody are eligible to file pre-grant opposition if they feel that it is not meeting the requirements of grant of patent. That is, it is not a subject matter, patentable subject matter. It doesn't have novelty or utility or non-obviousness, or it doesn't properly, specification is not properly written. Anybody can file a pre-grant opposition. And once a pre-grant opposition is done, filed, the examiner will take into account the pre-grant opposition, examine the patent application in light of the requirements, that is subject matter, novelty, utility, non-obviousness, and specification. If your application does, if your patent application does not meet this criteria, the examiner will issue first examination report, and you will be allowed to file a reply or response to first examination report within 6 months. Earlier to 2016, it was 12 months, but from 2016, it has been made 6 months. Once you file a reply, the examiner, if satisfies, grants or refuses your patent. Before refusing, if he had to refuse, before refusing, he'll call for a personal hearing. He'll hear you out on the requirements, whether it is subject matter, novelty, utility, non-obviousness, specification, why it is not fulfilling that criteria. You need to explain why it is fulfilling. The examiner will say why it is not fulfilling. You need to convince him why it is fulfilling. And if you are able to convince him, then he'll grant a patent. If you are unable to convince him, he'll be refusing. After the hearing, the patent office will give you 15 days time to file written submissions of your hearing. After filing written submissions, the patent office will go through the written submissions and either grant or refuse your patent. In case it is granted, you need to file renewal fees every year until 20 years. First 2 years are exempted. From third year onwards, you need to file renewal fee. Every year you need to pay renewal fee. Before the expiry, you need to pay renewal fee. If it is 6 months extension period, 6 months extension of time will be given for filing renewal fees. And then along with renewals, you also require to file working of patents every financial year and say how many products you have manufactured or sold in the market or licensed your technology. And then it is also post-grant opposition. It is also open for filing post-grant opposition. Once a patent is granted, within 1 year, any person interested, earlier pre-grant opposition is anybody and everybody. Here, post-grant opposition, only interested party can file opposition. Interested party is the person who is involved in the technology, either for research or manufacturing or sales. If he is involved in the technology, he becomes the interested party, and he can file a post-grant opposition saying that it is not meeting the requirements, patent need to be cancelled. If you miss the bus of post-grant opposition of 1 year, then don't worry, you can also file a revocation petition at any point of time before 20 years, even at 19th year of your patent. People can file a revocation saying that it is not meeting the requirements. If it is meeting the requirements, your patent will be continued till 20 years. If it is really not meeting as alleged by the revocation petitioner, then the patent will be cancelled, revoked. These are the requirements that have been narrated in the provisions of the law. Subject matter has been defined under Section 2J. What is an invention has been defined under Section 2J. What is an inventive step has been defined under Section 2JA. And what is industrial applicability has been defined under Section 2AC. So to get a grant of your invention, it should fall under these definitions. And outside the definition of Section 3 and 4, Section 3 talks about non-patentable invention. Section 3A to Section 3P, there is a long list of non-patentable inventions. Then Section 4 talks about atomic energy related patents, not patentable. Then novelty, Section 21J says that any new product or process. What is new invention has been defined under Section 21L. And then utility or industrial applicability has been defined under Section 21AC, and inventive step has been defined under Section 21JA. Then specification requirement has been narrated under Section 10 and Rule 13. The objective of patent system is to encourage inventions, to breed inventions, to update industrial development by working of the patented invention on commercial scale, and to avoid reinventing of the wheel. More importantly, once you breed the inventions in a particular database, people will go there, check in, and then if something is already existing, they'll not waste their time on time and money on R&D of the solution what is already existing. So it is avoiding reinventing of wheel, duplication of research. And it keeps abreast with the latest development in different fields of technology. With suppose I am doing some research on, say for example, COVID-19 drugs. That information is already available in the patents filed. Until today, whatever development have been done, that all will be filed in the patent applications. I can do a search, get the pace of the industry, and then do further research from there. It also serves as an indicator of achievement in R&D institutions and ability of individual researchers. Suppose I have 100 patents, I'll be looked at as a person equivalent to the great inventors. However, if I don't file any applications, I'll not be called a scientist. If I file 1 patent or 2 patents, I'll be termed as a scientist, irrespective of what technologies are filed. Similarly, if your institution, your college files patent applications, 10 patent applications you file, people look at you. And if you file 100 patent applications, people queue at your organization saying that you are a technology driven organization. So that R&D achievements will be indicated by the number of applications you file. Also, if your company, your business strategy will be based on the trends of technology, how technology is progressing. Suppose you have a pager manufacturing industry, and somebody invents a mobile phone and files a patent. The moment mobile phone is filed a patent application, you should get an understanding that pages will be outdated. So you need to strategize your business in such a way that what is the latest technology coming up in the market. So if you don't strategize your business and you go on selling the old products, you will be vanished in the market. There are various amendments that have been made under Indian patent law that is updated time to time from on the website, Indian official website called ipindia.gov.in. There it is, the Patent Act and patent rules have been updated. Patent law has been amended majorly in 1999, 2002, and 2005. Patent rules have been amended 2003, 2005, 2006, 2012, 2013, 14, 15, 16, 17, 19, 20, and 21. Even latestly this year also, the patent rules have been amended. Majorly, the amendment talks about type of applicant, like startup, individual startup, small entity, large entity. All those things will come under type of application. The fee for filing have been changed from time to time. The requirement of filing working of patent statement, that is under Form 27, how many licenses, how many products you sold, that required to be filed earlier it was every calendar year with 3 months extension till 31st March. Now it has been every financial year with 6 months extension, that is till September. Every year you can file. Earlier, for every patent granted, you require to file one Form 27. Now that requirement of filing for each and every patent one Form 27 has been done away, and one single form for all patents you have been granted can be filed under one single form. And the new amendment rules on February 9, 2021 has brought in this new type of entity that is called eligible educational institution. This eligible educational institution means anything that has been established by central government, provisional or state government, or owned or controlled by central government or state government or provisional government, either wholly or substantially financed by the government. If that is the case, that becomes eligible educational institution. When it becomes eligible educational institution, they are allowed to file, they're allowed to claim reduction in the fee, as well as they are allowed to file expedited examination under 24C, the fast track application they can make, and they can obtain patents faster. And then obtaining certified copies. Earlier, when you want to file applications in foreign countries, you were required to file certified copies. Once you file in India, if you want to file same application in a foreign country, you need to obtain a certified copy. What you filed on that particular day in India, the government of India would have put a seal and stamp and everything and sign it and give it to the inventor, so that he can file in other countries. If you're filing in 10 countries, 10 certified copies would require for you to obtain and file it in 10 different countries. Now these certified copies have been done away with the introduction of WIPO DAS digital access system code. So you need to provide this digital access system code to the foreign patent office. That foreign patent office will give this code to Indian patent office, and then they can access the patent application what you file. So that facilitated by WIPO, World Intellectual Property Organization. And IPAB, all appeals earlier from patent, whatever orders controller of patents would have been given, the appeals would have been lied in Intellectual Property Appellate Board. But on 4th April 2021, the IPAB has been abolished, and patents are now been, the orders of the controller are now been preferred to high courts. Then the competition law versus patent law. Patent law says that you should have a monopoly, but competition law says that equal competition should be there. When your patent is declared as a standard essential patent, industry standard, for example, in telecom area, 5G inventions, when a 5G invention has 4G or 5G invention has been made, the mobile manufacturers are mandated to adopt the 5G technology. Without 5G, mobiles should not be manufactured, is what telecom standard setting organization has been resolved. So now for manufacturing 5G technology, I need to take a license of the inventor. If the inventor does not give license to me, I will be out of the market. So it is killing competition. So what the competition commission said is, if you have a patent which become industry standard, you should license it. That there should not be injunction, or you can't stop others. However, you can give a license under a principle called FRAND, FRAND, fair, reasonable, and non-discriminative. Everybody equal price, equal license fee required to be collected by the patentee is what Competition Commission has said. There are a couple of cases that have been decided by Competition Commission, which allowed FRAND principles of licensing in India. And then Supreme Court has extended timelines because of the COVID, the timelines to do whatever actions in India on patent law that have been extended from time to time because of the Supreme Court order. Then India has signed with Japanese Patent Office a agreement called Patent Prosecution Highway. By this agreement, what happens is, if an application filed under this Patent Prosecution Highway in India or in Japan, if it is granted in India or granted in Japan, the other country will automatically grant it without further examination. So same invention, every country will examine it. Every country you need to reply. This is duplicating the work. So instead of this duplication, what patent offices around the world are doing is they are signing these agreements. Now India has signed with Japanese patent office. If Japanese patent office examines an application and grants a patent, Indian government automatically, without even examination, grants the same patent. Likewise, India grants a patent, Japanese patent office, without further examination, they'll also grant patent in their country. So that kind of bilateral agreements have been signed between the member countries, different member countries, and then patent prosecution highway is facilitated. In India, it is with Japan first, and Indian government is exploring further patent prosecution highway agreements. In 2012, Indian Patent Office has been designated as International Search Authority and International Preliminary Examining Authority for the purpose of PCT applications. For international PCT applications, whoever filed, Indian Patent Office is now qualified to provide international search reports. And large number of patents were granted in 2020-2021, though it was pandemic. More than 26,000 patents are granted in 2020, and more than 14,000 patents have been granted till June. Till June itself, more than 14,000 patent applications are granted. Then Section 3K, which says that computer programs per se are not patentable, has been elaborated by Delhi High Court. And they said earlier it was software which is fixed on a machine is considered to be patented, that is embedded software. Now Delhi High Court said if a software is technological softwares can be patentable, is what Delhi High Court said. And Section 25(1), which allows pre-grant oppositions, there were numerous oppositions were filed, and till 20 years oppositions are going on to be filed so that patent will not be granted to him. So this practice of filing multiple patent oppositions, the IPAB has said that no, you can't do that. If you have to file opposition, you need to file in the earliest stage, not at the tail end. 18th year or 19th year, you can't file pre-grant oppositions, is what IPAB has said. Now, for obtaining a patent, how do you do that? After patent search and drafting is done, you need to file for patent applications with one of the patent offices based on the territorial jurisdiction of the place of office or residence of the applicant or agent, or where the invention evolves. So based on that, the territorial jurisdiction is decided, and you're required to pay the fee. All information concerning how application form required to be filled, how it need to be filed, is available on ipindia.nic.in. There is a guidebook is available for applicant. Applicant can be a natural person or a legal entity. Under Section 6 and Section 134, either alone or jointly, true and first inventor can file a patent application. In case true and first inventor does not wish to file, his assignees, true and first inventor, can sell the invention itself to somebody, and that somebody can file on place of true and first inventor. In case a company is filing, company is construed as assignee of the true and first inventor. And then in case true and first inventor dies, his legal representative or his or her assignee can be filing an application either alone or jointly with some other person under Section 6 or Section 134. True and first inventor does not include first importer of the invention into India. If something is existing in USA or Australia and you are importing that invention in India, you are not called true and first inventor. A person to whom an invention is first communicated from outside India, that is also not. If it is communicated to you first, it is not your invention. If invention means true and first inventor, means the person who has invented this product, who from his brain it should have come, not from third party. Types of applications, you can file provisional or complete specification. In case you file provisional application, 12 months given to file complete specification. However, you have post dating of provisional application option is available up to 6 months. Then it is called ordinary application. If a citizen of this country, citizen or company of this country files an application, it is an ordinary application. And if somebody files from foreign country in India, taking priority of his foreign application under Paris Convention, it is called convention application. And then if you file multiple inventions together into one single application, either you can divide it on your own, or the patent office calls you to divide the inventions, multiple inventions, into different applications. That is called divisional application. In the period of once you file a patent application And before 20 years, if you have some improvements over that invention, trivial improvements, small improvements, then you can file patent of addition. When you file a patent of addition, it is not a new patent application that you are filing. Already existing technology, some small improvement is happened. That improvement also you want to claim. So you will file a patent of addition. When you file a patent of addition, no separate patent will be granted to you. The original whatever patent is granted, in that a new claim will be added, and that will be protected to you. That's the reason it will not get another 20 years. Whatever 20-year patent is been given to you in the same, if you file patent of addition on 19th year, you get only 19 to 20 years, 1 year only that improvement grant. Otherwise, patent of addition is not a new patent, it is existing patent. You add some improvement to it. Then PCT national phase application. If foreign country applicant coming in India, he'll file a PCT national phase application. If you want to file in foreign countries under PCT route, you will be filing as an Indian citizen. You will be filing PCT international application, so that you can file within 30-31 months in other foreign countries. Otherwise, you can file convention application in foreign countries. To avoid filing convention applications, you can go through PCT international application. Once you file a PCT international application, the 12 months will extend to 30-31 months, and you get an international search report. And within 30-31 months, you need to file PCT national phase application in respective countries. There are 4 patent offices in India: Delhi, Chennai, Kolkata, and Mumbai. Kolkata being the head office. Territorial jurisdiction: Bombay, Delhi, Chennai, and Kolkata for the rest of India. What are the forms that are required? Application form, form 1, with the details like name and address of the inventors, name and address of the applicants, along with the title of the inventions, and declaration of your inventorship, and declaration of your assignment, declaration of your deposit of microorganisms. All these declarations required to be made in the form 1. Then form 2 is, in case provisional specification or complete specification, the details of the specification. What is that you have invented, how that machine required to be constructed, how that product required to be used. All that information you need to file in the form 2. Form 3 is statement undertaking. Statement to the effect that you have not filed any foreign applications, or that you have filed any foreign application that on the similar invention. And in case you file in future a foreign application, or in case in the future your foreign applications are published or refused or granted, that information you will communicate to patent office. Statement to the effect that whether you file foreign applications or not, and undertaking to provide details of foreign applications in future time. Within 6 months from filing any foreign application, or any action happened, publication, refusal, or a grant happened, that need to be communicated to the patent office, because you are filing a statement and undertaking to file those information under form 3. Form 5, declaration of inventorship. Every inventor need to sign that. They need to say that it is my own invention. I have not copied from else. It is coming from my brain only. That declaration has to be given under form 5. In case you are filing a patent application through an attorney or an agent, you need to file form 26, giving him authority to represent you as an applicant before the patent office. Then form 9, request for early publication, which is optional. If you don't file form 9 after 18 months, the patent application will be published. If you file early publication request, every Friday the patent journal gets published. Within next, if you file today, coming Friday, or if you file on Wednesday or Thursday, next Friday will be published. Your application will be published in the journal. Then form 18 for request for examination, form 18A for request for expedited examination, which can be filed within 48 months. If you want the application should be pending for a long time, you can file at the 48th month. Otherwise, if you want it to be examined quicker, then you can file along with your application form 18. If you want expedited examination, you can file form 18A. Unless you file for this form, even if you file a patent application, that will not be examined, and eventually after 48 months, if you don't file form 18, your application will be abandoned. Your application will be queued for examination only when you file form 18. Then form 28, declaration of micro entity or eligible educational institution or startup need to be declared in the form 28 to claim the fee concession. That form 28 has to be filed. And form 27, working of patents after the grant every financial year within 6 months has to be filed. One single form for multiple patents can be filed under form 27. Form 2, Section 10, read with Rule 13, talks about filing of a provisional or complete specification. The specification contents, you need to mention title, what is the title of that invention, technical field, what field of technology it is. If it is generally two-part statement, a broad technological field followed by a specific technological field in which your invention falls into. Then background and prior art. What is the background, how this invention was, how this product was handled earlier, what are the different technologies already existing, and what are the problems with existing technologies, drawbacks, gaps in the existing technology, and solution to that problem or improvement what you are invented required to be filed and required to be narrated. And you need to summarize your invention, and then detailed description, a complete description about your invention, how it is, what are the different parts, how each part is connected to other parts, what are the experiments you have done, what are the trials you have done, what are the examples to use your invention, you use your product. All that need to be narrated in detailed description. And then you need to write claim. Without claim, it is not called a specification. You can file a provisional specification without a claim, but when you are filing a complete specification, definitely you need to draft a claim. Without a claim, when you draft when you file a specification without claim, it will be refused, saying that it is not meeting the requirements of the law. Claim is one of the requirement of the law. Unless you claim is actually a boundary for your invention. What is that you want to claim? What is you want to stop all others from using? That will be going into the claim. And then every article you write in journal publications and all, you write an abstract. Similarly, for patent specification also, you need to write abstract. And in case you are unable to describe the invention by words, you can also take the support of drawings if you are unable to draft in words what the specification, what the invention is. Then in case you don't want patent application in India and you want to file abroad first an application, then you need to make a permission for filing application abroad under Section 39, read with Rule 71 on Form 25. You need to make an application for filing application outside India. If you are not filing application in India, if you're filing application in abroad, any separate application. But however, if you are making an application outside India without filing application in India, it is mandatory that you need to obtain foreign filing permit. If you fail to file foreign filing permit, it is a punishable offense, and also your patent will be revoked in India. If you file a patent application later, it will be revoked on this ground. Then the objective of filing foreign filing permit is, it is patriotic basically. If you made an invention which is relating to Indian defense or atomic energy, the government of India doesn't want you to disclose it outside. They'll give secrecy directions and ask you to keep it secret, because it is helping your motherland. It is helping defense of India. So that information should not be given out is what the objective of this provision. And controller generally will dispose of this foreign filing permit application within 21 days from the date of filing of such request. He'll only check whether your invention is falling of the interest of Indian defense or atomic energy related invention. If it is falling, it will be referred to Ministry of Defense, and Ministry of Defense will take a call whether they want this invention for themselves or whether they permit for commercial usage. If they permit for commercial usage, you are free to disclose. If they do, if they say that requires for Indian defense, then secrecy directions will be prevailed and your patent will not be granted. The invention will be taken over by Indian defense and you will be paid a soletum small amount. Then once a patent application is published, patent application will generally be kept secret for 18 months. After 18 months, it will be published. In 19th month, the application will be published. The journal is made available on the website every week on a Friday. Applicant has an option to get this application published before 18 months also. In that case, application is published within 1 month. That is from the making of a request, within 1 month, it will be published. And as I said, request for examination is mandatory. If you don't make a request for examination, it will not be queued for examination. Request for examination can be made by applicant, or any third party can also make a request for examination. Once a request is made, application is sent to the examiner within 1 month from the date of the request, and the examiner undertakes the examination whether the claimed invention is not prohibited for grant of a patent or whether the invention meets the criteria of patentability. Once that is done, he'll issue a first examination report within 3 months. And then once the first examination report is issued, 6 months time will be given to file a reply. Then pre-grant opposition from the date of filing application. 6 months is a mandatory period that controller should, before granting a patent, he need to wait for pre-grant opposition. If nobody files an opposition within that 6 months, and if the examination is all over, then after 6 months the patent can be granted. However, if patent is not granted beyond 6 months also from the date of publication, until patent is granted, oppositions can be filed. The opponent will be given an opportunity of hearing before deciding the pre-grant opposition. Then examination of pre-grant opposition documents will be sent to the applicant. A 3 months period will be given to file a reply. Once a reply is filed, it will be either refused or continued to examination. Pre-grant opposition grounds can be it is already publicly known or used information, or there is a disclosure of biological material that is not sufficient, or it is wrongfully obtained. I have invented, but he has filed a patent application, or it is already prior publication is there. Post priority publication, but prior claiming, before claiming your invention, it has already been public information. Information regarding foreign applications are not filed under Form 3. Section 8 and Form 3 mandates you to file information regarding foreign applications, that if you don't file, that is ground of opposition. Or it is a traditional knowledge in India or in any other country, or it is not fully disclosed, or it is not patentable subject matter under Section 2(1)(G) or Section 3 or Section 4, and or it is filed from a foreign country, convention country, after 12 months, or it is lacking inventive step. All these are the grounds for filing a pre-grant opposition. Once it is filed a pre-grant opposition, the examiner will look into it, and he'll either reject or modify the application to grant a patent. Once a patent is granted, a certificate of patent will be issued 7 days, and grant of patent is also published in the official journal. From that date, 1 year time frame will be given for post-grant opposition to any person interested. Then once a patent is granted, you need to file every year renewal fee, and you need to file working of patents. Inventions are to be worked in India on commercial scale, failing which compulsory license will be issued. In 2021 patent rules, prescribing Form 27 for financial year with 6 months time to file the details of working. Renewal fee need to be paid within 3 months to 6 months from the date of recording of the patent. No fee for first and second years. Renewal fee on a yearly basis is required to pay 3rd to 20th month to keep patent in force. Delay up to 6 months from the due date is permissible on payment of fee of extension of time. Patent lapses if renewal fee is not paid within the prescribed time. Then revocation proceedings, if any person interested before 20 years, he can file at any point of time before the expiry of 20 years, he can file a revocation application similar to the grounds of opposition. Patent invalidity can also be claimed before the High Court in infringement proceedings. Either revocation or invalidity will go ahead, not both. As per Dr. Alai's Oben case, Supreme Court decision, if you file revocation, that will go, or if you file invalidity, that will proceed, not both together. So if you have filed revocation, then you need to say to the court that I have filed revocation, that need to go ahead. Or if you file invalidity, then you need to stop proceedings under revocation. So both can't coexist is what Dr. Alai's Oben case says. Just because what happens if High Court says patent can be continued and Patent Office says patent can be revoked, there will be conflicting decisions. To avoid the conflicting decisions, any one of them will go ahead and not both. Then patentee at any time before the expiry of the patent term can surrender its patents by issuing notice to all interested persons in the patent, the licensees or assignees, whoever is there, all the persons he'll need to give the notice, and then he can surrender the patent. That's about it. If you have any questions, you can ask me now.
Yeah, thank you very much, sir, for great information related to filing process in India. Sir, I have received few questions. So one is related to PhD work or a research work, that will patent, if we file patent before a research paper, so will it affect to the plagiarism issue? In this case, what we should prefer? We should go with paper or we should go with patent?
You should file a patent application first before submitting the PhD thesis. It is, since it is your own disclosure, it is not called a plagiarized thing. So because it is your own disclosure, your own work, plagiarism will affect your work will be treated as plagiarized if you copy somebody else's content.
Right.
If you are using your own content, you filed your own patent application, and you're filing thesis of the same patent application, that is not considered as plagiarized thing. So
Right.
I would recommend that you first file a patent application and then
Okay.
submit the thesis.
Okay. Okay. Thank you, sir. Also, sir, there is an innovation patent available in Australia. So, what is the difference between the normal patent and this innovation patent?
Yeah, this is called utility model PT patent. There are different names. In Australia, they call utility innovation patent. In some other countries, they call utility patent. In some country, utility model. In some countries, they
Right.
call PT patents, short-term patents, and all. So, unlike stringent requirements for grant of a patent, for innovation patent or PT patent or utility model, the requirements are nominal. If you can show some innovation, some novelty in it, the patents will be granted. It is for a shorter term, 5 years to 7 years is what the term is provided under utility patents. India, we don't have utility models. China,
Right.
Australia, and some countries have utility models. But then
Right.
most of the countries are now doing away with utility model patents.
Right.
They want regular patents to be given. However,
Right.
it is good to have utility model so that we'll encourage small software patents. For example, software
Exactly.
changes within 3 years. It doesn't require 20 years protection. It requires only the 3 years or 4 years protection because the version completely changes. So such kind of inventions can be granted the utility patent. Utility models is what what I think is better. But in
Right.
India, we don't have utility models.
Okay, okay, sir. And the last one, that we know that right now industry is moving towards industry 4.0, and software industries are also moving towards AI integrated systems. So how to go for this kind of pattern? Will it the process same?
It is no different. It is one and same. Whether regular technology, mechanical or automobile or electronics technology or AI based technology, it is no different. The rules are same. The requirements of law, that is subject matter, novelty, utility, non-obviousness, and specification. These are the 5 requirements. Only these requirements are applicable for any kind of invention, any technological invention, be it blockchain, be it artificial intelligence, be it software patents, be it any new technology, IoT or anything. All that requires these 5 requirements required to be fulfilled. Only when
Oh,
these 5 requirements are fulfilled, the patents will be granted. However, there is
oh,
some debate happening for AI, artificial intelligence related patents. Who
right.
should be called as inventor? Is it a machine or
Exactly.
a human being? Who should be called inventor? There was this debate happened in a big way in Europe. One of the patent appeals, the enlarged board has given a decision saying that uh, machine cannot be called as inventor. However,
Right.
whatever artificial intelligence, machine learning, whatever it has done, it never be called a inventor. It is
Right,
not
sir.
can be called as an inventor, not a
Hmm.
machine be called an inventor. So, patent in the patent application, the name of the inventor should be the name of the person who created that machine, who
Right.
create the software engineer who designed that AI, the software
Exactly.
engineer who designed that learning thing. That person will be named as inventor, not the machine. Is what has been decided by enlarged board of appeals. Similarly, in copyrights also, if you see that
Okay.
monkey selfie, there were huge controversy happened, and people
Exactly.
say that monkey is the author of the photograph, and monkey should be given copyrights, not the photographer. So there also the decision came in favor of the animals will not have any intellectual property rights, but the person who made that animal to click that picture, is the copyright holder, is what that case also be decided.
Right. Thank you, sir. And so last one is software alone can't get a patent. Hardware integration is required. Is it a myth or reality?
Until that judgment by Delhi High Court, it is quite uncertain what software is patentable and all. And lastly, because of the CRI guidelines, computer related inventions guidelines given by patent office, people felt that they have divided software into two categories. So one is software that is been installed on a general computer, that is regular using mobiles or laptops or tabs. In that, we'll install the software and use it. That is general purpose software. And there are specific purpose softwares. For example, if you want to run a Xerox machine, you need a software to run that machine. So that is an embedded software. So embedded softwares and general purpose softwares have been divided, and only embedded softwares will be given patents, is what CRI guidelines have said. But then Delhi High Court recently has given a judgment saying that if software is technological, the software a software which generates music from your laptop, or a software which is a search engine, those kind of things are technological softwares. Those technological softwares can also be patentable, is what Delhi High Court said. But what is technological is again a subjective term. What is technological to me might not be technological to you. So what is technological, what is technical effect is not defined anywhere. So you have, again, there is no clear-cut guideline, so you can take advantage of this. You can file software patent application, everything, and say all your software is technical when it comes for defending your patent. And when you want to invalidate a patent, you can always say that there is no technology involved in this. Under Section 3K, it has to be invalidated. So you can play around with the law.
Right. Okay. So you mean to say that if we train our model, or if we develop any AI system, and if we deploy it on Google or Amazon cloud, still we can go for patent. We need not require to take a permission from Google or Amazon.
This is very pertinent question. If you have used any open source tool or a patented licensed tool for developing your product, then though you file a patent application, you might get a patent granted to you. But then when you are actually going in the market, you might require their permission. So when you are using open source tools, the open source licensing itself, the license itself talks about what you can do, what you can't do. The tool itself says that, the license itself says that this tool can be used for filing a patent application on a technology that has been developed over this tool or not. If they say that, if the license says that you can't do it, you can't file a patent application also. But if the license application says that you can file a patent application, but you can't commercialize as you wish, you have to go by that license. So the license agreement governs the applications under such systems. If there is nothing, like if you have filed a patent application without any terms and conditions, the license, and you got a patent based on a technology given by some third party, so you need to obtain their permission to commercialize it.
Okay. So thank you very much, sir. Yes, exactly, sir. So thank you very much for your precise time, and once again, thank you very much that you have spared time for us from your busy schedule. So thanks a lot. Thank you very much.
Thank you.